Welcome to the South Carolina Probate Court. The purpose of this video is to provide you with a basic understanding of the probate court system and the process of estate administration in South Carolina. Probate court is a specialized court that oversees estate and trust administration, adult guardianship and conservatorships, marriage licenses, and mental health proceedings. In South Carolina, probate judges are unique because they are elected by the people in each county, and they serve 4-year terms. In South Carolina, each county has a separate probate court. Although the law is the same that governs all probate courts in South Carolina, there may be some specific procedures within each county. Before filing in your county probate court, please check to see what differences there may be. In addition, county probate courts sometimes provide forms and other information on their websites. Local judicial staff at your county probate court can help you navigate the website and assist you with these resources. However, please keep in mind that court officials and court clerks cannot give you legal advice or advise you on how to prepare legal documents. The law allows you to represent yourself in probate court. However, the laws and rules that govern probate courts can be complicated. Only an attorney can properly advise you of your legal rights, provide legal counsel, and act on your behalf. To protect your legal rights, you're strongly urged to consult an attorney. This video is not a substitute for legal or accounting advice. You should consult a local probate attorney in your county to help you with detailed questions. If you would like assistance finding a licensed probate attorney in your county, please contact the South Carolina Bar's Lawyer Referral Service at 1-800-868-2284.
Hello, my name is Judge Waldo, and I'm a probate judge in South Carolina. This video will provide an overview of how to close an estate in South Carolina. In South Carolina, you have a time frame of 8 to 12 months to close an estate. Now that 8 to 12 month time frame begins to run with the first publication of notice to creditors. The forms associated with closing an estate are intended to provide the court with an overview of what assets came into the estate, what debts were paid, and how the assets were distributed. In this video, we will follow a widow as she copes with the death of her husband and attempts to close her husband's estate with the help of her lawyer.
Well, Miss Louise, it's good to see you again.
It's good to see you again. This shouldn't take very long because I'm very prepared this time.
Well, great. And you're right. It shouldn't take too long.
Well, let's get started because I haven't seen your bill yet.
Well, we better not waste any time. So let's get started closing your husband's estate, okay? The first step we want to look at today is the creditors' claims, expenses, and fees, okay? Now, have you received any creditors' claims against your husband's estate?
It is the responsibility of the personal representative to review the validity of all claims against the estate and decide whether to pay, compromise, or disallow a creditor's claim. If a creditor's claim is paid, the personal representative must file a signed receipt and release form with the probate court. This form acknowledges that a creditor received payment. Anyone else receiving something through the will or by inheritance must also sign a receipt and release form. If they do not sign a receipt and release form for some reason, then a court hearing may be necessary. If a creditor's claim is not valid, or if there are not enough assets to pay all the creditor's claims, then the personal representative must complete a notice of disallowance of claim form, mail it to the claimant, and file with the probate court. This form, along with other probate court forms, are found on South Carolina Judicial Department's website, www.sccourts.org, under Court Forms.
I did not receive any creditors' claims, and I'm very happy about that. Now, the funeral was prepaid, so that expense didn't come out of the estate. I also paid the probate court fees, the newspaper advertisement, and the court fee based on the inventory and appraisal.
Well, good job. You've been busy, huh?
Yes.
Well, the easiest way to close your husband's estate is to look at the inventory and appraisement form that we completed, okay? Now, Schedule A lists all of the real property. home and the timeshare. Both the Florida timeshare and your home were included. Is that correct?
Yes.
All right. Well, let's start with the transfer of your home.
To transfer a real property, the personal representative must complete a deed of distribution, which is not a deed in the traditional sense. A deed of distribution does not pass title. It just shows that the personal representative released the property to its rightful owners. A deed of distribution is a legal document that is filed in the county where real estate is located and where deeds are typically recorded, either in the clerk of court's office or the register of deeds office, depending on your county. The deed of distribution becomes part of the chain of title to real estate, so it's very important that your property description is accurate.
Okay, I've completed and signed the deed of distribution like you asked me to.
Well, good. Now, for the Florida timeshare, I ordered your exemplified copy from the probate court. Okay. Now, did you file when you traveled to Florida?
Yes.
Okay, this looks good. Now, this is what I will provide to the court as proof of the transfer.
Okay.
But as for the stocks and the bonds, I'm going to need copies of those transfers as well.
Okay, I got these from my financial advisor.
Oh, this is perfect. All right. Well, let's move on to the remaining schedules, okay? I'm going to need copies of any new titles that have been transferred. This can include vehicle, boat titles, business transfers, or updated cemetery plot transfers in your name.
Okay, I think I have everything you need.
All right. Good. All right. Well, let's move on to the accounting form.
Between 8 and 12 months after the first publication of the Notice to Creditors, you must file a complete accounting of the estate administration with the probate court. The accounting form provides an overview of the estate from beginning to end and is one of the more complex forms to complete. The personal representative must account for 1. All probate assets that were identified on the inventory and appraisement form, 2. All receipts that have come into the estate, and 3. All disbursements made from the estate. There are 2 categories on the accounting form, the receipts and the disbursements category. Under receipts, the personal representative must list all of the assets and income received by the estate, including all rent, refunds, or dividends that come into the estate after death. Under disbursements, the personal representative must list all expenses paid out of the estate, including attorney's fees, taxes, and court costs, and any creditor's claim. Note that usually non-probate assets are not listed on the accounting form. Some probate courts exempt the accounting if the personal representative is the sole heir. Check with your local probate court for more information if you think this may apply to you.
I think I have all the accounting forms and I have all of my receipts right here.
Okay. Let me see what you have here, Ms.
Okay.
Lewis. Thank you. Oh, this looks great.
Good.
Now we need to complete the application for settlement next. Now this form asks the court to approve and accept the filings to close the estate. In this form, you state that you've filed all of the necessary paperwork and that you filed an income tax return if necessary. Now, if you're not certain as to whether or not you need to file an income tax return, then you need to contact your CPA or your tax advisor, okay? And this is the form here, but of course it needs to be notarized, so I'm going to need to call my assistant in. She can notarize this for us, okay? Hi, Stephanie? Yes, I'm going to need a document notarized here, please. Okay, thank you. She'll be right with us, Miss Louise.
Okay.
Ah, here she is now. Stephanie, need this document here notarized. Miss Louise, if you would, please, ma'am, just sign right here.
Sure.
Thank you.
Thank you, Stephanie.
In order to close an estate, there are several things that you must do. You must demonstrate the following to the probate court. 1. All claims have been satisfied. 2. All assets have been transferred to the appropriate successor. 3. No assets remain in the name of the deceased person. And 4. It is appropriate to close the estate. The personal representative must also file several forms with the court to close the estate. The following items must be filed with the probate court within 1 year after the date of the first publication of notice to creditors. 1. The accounting. 2. A proposal for distribution if assets have not been distributed. 3. An application for settlement. And 4. Proof that the notice of the right to demand a hearing and copies of the final documents were sent to all interested parties, including creditors.
And as long as no one demands a hearing, we will receive a closing order signed by the judge and your husband's estate will be closed.
Okay, great.
All interested parties, including unpaid creditors whose claims have not been borrowed, must receive notice of the right to demand a hearing and copies of the accounting, the proposal for distribution, and the application for settlement. If no written requests for hearing are received by the probate court within 30 days, the probate court will usually close the estate and terminate the personal representative's appointment. If a hearing is requested regarding any matter related to the estate administration, the probate court will set a hearing date. Please note that even after an estate is closed, the estate will remain on file with the probate court, and it is a public record.
In this video series, we have learned a lot about the probate process, and it can seem overwhelming. Probate law and the handling of an estate can be a complex process. An estate including only a house, a single bank account, and little personal property will probably be far easier to deal with than an estate containing multiple properties and assets that are left to numerous beneficiaries. These types of cases can become especially complex. Remember that probate judges and attorneys deal with these issues on a daily basis. If you need to probate an estate, you should consider hiring a licensed attorney who is familiar with South Carolina probate law. If you have complex estate or tax questions, you should consult an attorney.